John, excuse me.
Good evening, this is John Milburn for Laws 13010. It's evidence. We're into week 10. Tonight we're talking about circumstantial character evidence. We're talking about probity, prejudice, similar fact evidence, whole lot of terms. To make this a little more realistic, I was driving back from court to tribunal today and I thought, let's introduce the court of mum and dad and see how this works in practice. So let's assume that we have the court of mum first of all. We have a young boy, it's raining outside, and mum, who's pretty busy, says, Jimmy, don't go outside, because Jimmy does this. It rains, so what does Jimmy do? He runs outside and gets wet. So mum says that, she turns around, 5 minutes later she sees Jimmy at the edge of the kitchen, dripping wet, and says, you did it again, didn't you? You went outside. And he says, no, I didn't. Anyway, she says, all right, let's have a look at it. And she sees a trail of water leading from the back door. When she heard the back door close, and the back door goes through a carport out into the backyard. And she said, you were out in the backyard, weren't you? No, I wasn't. Well, why are you wet? And Jimmy says, I just had a shower. With your clothes, full clothes. Is that what you're telling me? Yep, that's what I'm telling you. I had a shower and I was fully clothed and I didn't go out into the yard. Okay, well, and the court of mum was just about to pass judgment and impose sentence when the court of dad intervened. And the court of dad considered even less evidence. And the court of dad walked in the front door, hi, I'm home. Oh, Jimmy, you've been out in the yard again. How many times have we told you not to do that? You're always doing that. Up to your room. So I don't know how the court of dad seemed to sort of just presuppose that it would impose the sentence, and the court of mum didn't have any say in the ultimate sentencing. So in the context of circumstantial evidence, which is really what we're talking about tonight, the court of dad didn't really look at much circumstantial evidence, but there was some circumstantial evidence. So what would be the main item of circumstantial evidence in this case? What did the court of both mum and dad look at?
Jimmy was wet.
Exactly. All right. And I guess we need to just do a refresher. Circumstantial evidence is essentially anything other than direct evidence. And what's direct evidence? Things that you see, things that you hear. So arguably, mum, in hearing the back door close, well, that's some direct evidence. It's not necessarily the best direct evidence, but some direct evidence. But the fact that no one saw Jimmy in the backyard, no one saw Jimmy get wet from the rain, but it's a pretty strong circumstantial case, isn't it? So mum saw, she knew that she'd given the direction. She saw the child, Jimmy was wet, and she traced back and saw that the trail of water led from the back door. And Jimmy's story about being at the other end of the house in the opposite direction and having a shower was clearly not correct, because the circumstantial evidence just didn't support that version. But mum looked at a little bit more circumstantial evidence, didn't she? I don't know if dad did. Dad didn't look at much at all. But what other circumstantial evidence did mum take into account before she almost passed sentence?
It was repetitive.
He was what, sorry, Donnie?
He has been done before. He has done that before, previously.
Well, did mum, I guess mum didn't have a chance to pass her sentence. Maybe she did take that into account, but not on the version that I mentioned. Dad certainly did. Dad came in and said, look, you've been doing this before. Maybe mum did as well. But yeah, all right, so we'll take that as a form of circumstantial evidence, and we'll talk about that, which is really similar fact evidence. So that's good. What other circumstantial evidence did mum take into account? So we've got the fact that Jimmy was wet, the fact that Jimmy's done it before, so there's similar fact evidence, or propensity evidence almost. What other circumstantial evidence did mum take into account?
The floor to the back door was also wet.
Exactly. Okay, so there was the trail of water. Now, she couldn't necessarily say whether the trail of water was from the kitchen to the back door or the other way round, but she did make what you'd think would be a fairly reasonable inference, wouldn't you? And that is that the water was a trail from the back door to where Jimmy was found and not the other way around. So when we're talking about the circumstantial evidence, we're really talking about something that's not direct, but we are talking about facts. I mean, the fact is Jimmy was wet. That's a fact. There was a trail of water. That's a fact. And Jimmy's done this before. That's a fact as well. So they're all facts, but they're circumstantial facts. They're facts relating to circumstantial evidence. It's not direct evidence. Nobody actually saw him in the rain getting wet. But it's pretty strong circumstantial evidence. Strong enough that it's probably reasonable, you would think, that Mum could properly infer from the facts that she knows that are circumstantial that Jimmy probably did. Jimmy probably is guilty. Okay, so when we're talking about circumstantial evidence, we're talking about something which is a fact from which you can infer other facts, facts that directly relate to the offence in question. Now, it's not an offence to walk through the house wet, was it? Mum didn't say anything about you're not allowed to walk through the house wet. Mum didn't say anything about leaving a trail of water from the back door to the kitchen. The offence was committed by being in the rain, which is, let's say, in the backyard in this factual situation. Everything else is circumstantial. Okay, so that's how the court of mum and dad work. It considers a lot of circumstantial evidence, but it still has the power to convict. And so it is in real life in courts that people do find themselves being convicted of offences based purely on circumstantial evidence. Now, what if Jimmy had said, when questioned by Mum, yes, Mum, I did go out into the backyard and I did stand in the rain and I got wet. Now, what sort of evidence would that be? What's the opposite to circumstantial evidence?
Direct evidence.
Exactly. So it's direct evidence. And it's the same probative value. Diane says direct evidence. So it has the same probative value, if you like, as, or probably even more so, than a direct observation from an observer. So if a witness came in at that moment and said, I saw Jimmy standing in the backyard getting soaking wet, that is direct evidence of an eyewitness, yeah? So that's different to circumstantial evidence that we've been talking about. So an admission of guilt is itself direct evidence. But we didn't have that direct evidence and we didn't have the eyewitness in this case. So we're still working about circumstantial evidence. Okay, let's just take that step a little further. And after the court of dad has imposed sentence and sent Jimmy to his room, let's assume that mum and dad say, let's go and check if he's ruined the turf again. You know, he's always going out in the wet and ruining the turf, which has just been newly laid and they don't want it to upset the garden. They go out to the yard and they find that in the carport, which is between the yard and the back door, an open carport, they find a hose is running and it's running at full steam. The hose is running and there's water just pouring out of this hose. Now, what sort of evidence is that in relation to Jimmy's potential guilt or innocence? Is it relevant? I know the trial's finished, but we're now talking about a potential appeal point here for Jimmy. The hose, which is in the carport, is running and there's a lot of water coming out of that hose. And the carport is directly between the back door and the backyard. What do you think, Catherine? So
It's more circumstantial evidence. You've
It's,
actually seen.
Exactly. It's more circumstantial evidence. It's circumstantial evidence that wasn't led at the trial. Jimmy didn't lead it, but Jimmy didn't have to say anything, did he? He chose to give a story, but that probably wasn't right, that story, was it? But now we've got an extra piece of circumstantial evidence. In the carport, we've got this hose running. And what's the effect of that circumstantial evidence if it had been led at the trial of Jimmy in the court of mum and dad? What would be the, if you like, the legal effect of having that extra evidence in the context of Jimmy's supposed guilt?
There's an inference that can be made that Jimmy was actually out in the yard with the hose and turned the hose on.
Yes, he could have been in the yard and Jimmy could have turned the hose on. There are other inferences that you could reasonably draw from that fact, though. One is that Jimmy didn't actually go into the yard at all and that he didn't actually get wet from the rainwater, but for whatever reason, Jimmy turned on the hose while he was in the carport, completely dry and not affected by rain, and put the hose on himself and doused himself from the hose water. Now, you remember what Jimmy was not to do was go out into the rain, not to go out into the yard into the rain. So I guess what we're saying is if the charge is one of going out into the rain and getting wet, we now have circumstantial evidence that is consistent, reasonably plausible with his innocence in relation to that charge. Sure, he's still wet, and maybe we've got a statutory interpretation issue to argue, but in terms of the charge, don't go out into the rain in the yard and get wet, now we have circumstantial evidence that we can present to a court that is consistent, reasonably consistent with a hypothesis that Jimmy is not guilty. What do you think? Worth running? If you were defence counsel, would you now say, now that we've got that information, Jimmy, I don't think you should plead guilty. I think you should run this trial. Have we got enough?
I'd say yes, it raises a reasonable doubt.
There is a reasonable doubt, absolutely. Okay, so what's the test in terms of circumstantial evidence? When is circumstantial evidence enough? And the answer is it's enough if there is no hypothesis which is available that's reasonably consistent with innocence. So when we look at this situation, and if a jury, which is the court of mum, let's say, had convicted on those facts, I think you'd appeal it. And you'd appeal it on the basis that there was, in fact, a reasonable hypothesis on the facts as presented which were consistent with innocence. It doesn't matter necessarily what Jimmy said, but we look at the actual facts. Now, of course, prosecution will make a big thing of the fact that Jimmy lied, and the fact that he lied is consistent with guilt in that his lie was meant to cover up wrongdoing, and that his lie was consistent in what we call motivated by consciousness of guilt. So the lie is going to be a problem for Jimmy, even with this additional circumstantial evidence, perhaps. How do we deal with that lie situation? Is it an admission of guilt by telling the lie? Because he didn't go to the shower and turn the shower on, did he? Because the shower's at the opposite end of the house. But are there other ways that we can explain away his statement? Well, maybe Jimmy's a little kid. He doesn't really understand the difference between a shower, as in what we think of a shower in the bathroom, as opposed to dousing himself with a hose in the carport. He might call that a shower. We probably wouldn't. But he might say, so maybe what he said was true. Mum, I didn't go out in the yard. I didn't go out in the rain. I wet myself in the shower. It's a matter of terminology. But let's assume that Jimmy is still, despite that additional evidence, the court of mum and dad is still not convinced, and they're not prepared to find that the running hose in the carport was consistent with innocence. They look further evidence. They go to Jimmy's brother and they say, Tommy, do you know anything about Jimmy getting wet? And Tommy says, yeah, I do. I was in the carport with him and I thought it'd be funny. I turned on the hose and when he ran out, I doused him with water. Now we've got a bit more evidence, haven't we? Now we've got some direct evidence to supplement the circumstantial evidence. Anyway, the mum and dad, the courts of mum and dad decide that their decision is wrong at law. They quash the conviction. They get Jimmy down and they say, Jimmy, why didn't you say that your brother did this? And little Jimmy says, I didn't want to get him in trouble. And that was his motivation for the lie. Okay, so the point of what we're talking about tonight is really that there are levels of circumstantial evidence and that it is possible to convict someone on circumstantial evidence, but it's also clear that in many instances, conviction based on circumstantial evidence can be dangerous because circumstantial evidence won't necessarily always tell us the entire story. Now, when Dad walked in and the court of Dad just looked at Jimmy and said, Jimmy, you're doing it again, go up to your room, Jimmy was really, the court of Dad was really ignoring some vital circumstantial evidence. Didn't look at the water trail, just looked and said, based on credit, based on, if you like, propensity, based on similar fact, considered the past events of Jimmy doing this sort of thing as being circumstantial evidence sufficient to warrant a conviction. And I guess it's for that reason that it is dangerous, don't you think, to lead evidence of someone's prior convictions because it may have the effect of prejudicing people so much that they don't even look at the facts. They just look at the end result and say, knowing this person has this history, must be guilty, not even going to look at the facts, you're convicted. So in the same way that the court of Dad looked at Jimmy soaking wet and immediately assumed because of his past offending behaviour that he must be guilty, so a jury might do the same thing. So if in a criminal trial the prosecutor, in prosecuting a person on a charge of rape, says something to the effect that this person already has convictions, 3 convictions for serving rape, and is currently serving time for those convictions, how much evidence do you think the jury are actually going to listen to after that? Probably not much. They're probably going to determine there and then, all right, he's been convicted of rape 3 times in the past. He's serving time, so he was guilty for those. This was about the same time. He's got to be guilty. I'm not even going to, let's have morning tea, find him guilty and we'll go home. So evidence of people's past wrongdoing is still circumstantial evidence, yes, because it's not direct evidence. But it can be very powerful, but it can also be very dangerous. So for that reason, the courts make that type of evidence admissible only in really very limited circumstances. And you would have read about some of those things. Okay, so let's talk about some of the definitions that we're going to need to talk about. We're tonight talking about circumstantial evidence, but we're talking about it primarily in the context of evidence that relates to someone's character or their credit or their credibility. So credit, when you talk about someone's credit, we're talking about their character as a person. What type of person are they? When we're talking about their credibility, it's quite different. We're talking about their believability in giving evidence. So you might have someone who's a real rogue or a criminal, but you know, just someone that would trouble you because of their very bad character as a person, but they still might go into the witness box and tell the truth and be seen as telling the truth. In other words, just because they're a bad character doesn't mean that they won't be credible and believable as a witness. So you can distinguish those two concepts pretty well. Sometimes there's an overlap. The criminality in the past might be for perjury. Then the issues to do with his bad character or her bad character does affect the credibility. So that's one distinction. What about character versus propensity? So there are two different types of character evidence. The first is one that deals with a person's reputation in the community. Now, that type of issue may have really nothing to do with the case, but a person might generally have a good reputation in the community or a bad reputation. The other use of the term character relates to their behaviours in the past. So when we talk about someone's character, we might be talking about their general reputation, or we might be talking about their proven behaviour in the past, which is their propensity. So Jimmy had a propensity to run out into the rain and get soaking wet. So that's character evidence, but it's talking about it in the context of propensity. So Donaldson's case in Western Australia from 2007. It's in the textbook, I think. Donaldson was a swimming coach accused of sexually assaulting swimming squad members, and the court held that any evidence about his general reputation as being a great swimming coach had little probative value. That's not going to prove anything. But the fact that he behaved towards female trainees in the squad in a certain way is different, because that was talking about not his general reputation, but his behaviour in the past, his propensity. So Donaldson's a case that shows the difference between character evidence in terms of reputation as opposed to character evidence in terms of propensity. Now, the general rule is that propensity evidence is generally not admissible. Now, the Court of Dad let it in. The Court of Dad said, propensity evidence, I'm allowing that, and as a result of that, found Jimmy guilty. But a leading case on that is Fennig against the Queen. That's a 1995 decision of the High Court. And basically, Fennig is authority for the proposition that propensity evidence is not admissible if it only shows that the accused has a propensity to commit a crime. So that conviction of Jimmy in the Court of Dad, because in the past it'd been wet, you would probably try to exclude that on the basis that it's not relevant and it's dangerous to convict. It's highly prejudicial and it's not particularly probative to the decision. Okay, when we're talking about similar fact evidence, it's kind of a little similar in that we're talking about things that people have done in the past. It's not quite propensity evidence. There is a difference between the two. But when we're talking about propensity evidence or similar fact evidence, we're weighing up its probative value, its ability to prove something compared to the prejudice. And generally, the courts will guard against highly prejudicial evidence, even though you might think it's relevant, going into evidence, even if it goes to prove something, because the prejudice is so strong that it overtakes the mind of the person trying to make up the decision, or the jury trying to make up their decision. So the only time, essentially, the courts will allow propensity or similar fact evidence into evidence is if the probative value is such that it bears no reasonable explanation other than to implicate the accused of the offence. Catherine says, is Fennig in Queensland? No, it's a High Court decision. Let's see if I've got it here. Okay, won't be a sec. Fennig is 1995 182 CLR 461. So it's a High Court decision. So in Fennig, the court basically set some guidelines and rules as to when that propensity evidence can be admitted into evidence. And it's that issue of determining the prejudice as against anything else that may be there. I've got this new book. It's very good. It's Evidence Law in Queensland, South Australia and Western Australia. The advantage of that one is that it's dealing with the common law as opposed to the Uniform evidence acts. The other cases that you might need to consider in that context, and I'm reading from that book now, I'm just referring to that book, is Hock against the Queen. Hock is 1988 165292, and then Phillips against the Queen. These are all really good cases to put in your exam paper. If there is, and there probably will be a question about this. And Phillips is 2006 225 CLR 303. Then Roach against the Queen, which is a High Court decision. I'm sorry I don't have the reference to that just handy. And finally, there's a decision of the Queensland Court of Appeal of O'Keefe. So have a look at O'Keefe. I'll just see if I can get a reference to O'Keefe. So if you know those cases, or at least you can refer to those, then I don't need any more than that. You're welcome to, but they're the main questions. Yes. According to those, O'Keefe formulates the test for propensity and similar fact evidence. Yep. I didn't write the notes. I reviewed the notes, so definitely refer to O'Keefe. But I think you've got to be a little bit careful about talking about O'Keefe as a Queensland decision overriding the High Court. So just be careful about how you word things in that sense. And I hope that the notes aren't misleading in that regard. I don't think they are. Okay, so they're the main cases that you need to know in terms of these decisions. And I'll just see if I can find that reference to O'Keefe. Does anyone have the reference to O'Keefe handy? Because I don't have the notes with me. But I'm just looking through this text to see if I can find it. Yes, Catherine?
John, it's a 1999 QCA 50.
50, okay, yes. I think I've got another reference here, citation 2001 Queensland Reports at 564. Okay, thank you for that. All right, so we're talking about propensity evidence, we're talking about similar fact evidence. We know the cases that you need to look at. And look, I mean, this all went, Macon was an original case. I don't think we need to go back that far. So what were the circumstances in Fennig? Fennig was convicted of an abduction and murder of a 10-year-old boy. But between the day of that boy's disappearance and the trial, he was convicted of the abduction and rape of a 13-year-old boy, which was 12 months after the first child had gone missing. So, but the propensity evidence in the trial in relation to the subsequent abduction was that Fennig had lured the child into a van. It was a pretext, held him captive in the house, and he'd escaped. But what Fennig had done was leave a bicycle in a certain area where people would think that the boy had gone missing or drowned or something evident. So the factual situation between what had happened in the subsequent event was so close in terms of the MO, the modus operandi, that the court held that it should be admitted in Fennig. So the evidence against Fennig was already strong, but the evidence became really overwhelming with the addition of that similar fact evidence. So the court was talking about, well, what's the test? And it must be very strong. We'll say what it's not. Okay, so propensity evidence is not admissible if it only tends to show that the accused has committed crimes in the past or has a criminal disposition. He must have abducted and raped this child because he has a string of burglary charges and he's not a very nice person. That'll never get through as propensity evidence. So what is propensity evidence? According to the High Court, it is admissible if it possesses a strong degree of probative force. In other words, the probative force, the ability to prove something by way of evidence, according to the court, must clearly transcend the prejudicial effect of mere criminality or propensity. I think the courts talk in terms of it being an affront to common sense to exclude that type of evidence. It would be just silly not to allow that evidence to go into as part of the prosecution trial. All right, so what's the section in Queensland that deals with similar fact evidence? And where would we look for the statute that deals with similar fact evidence? What act? Any takers? All right, no takers for the Act. The Evidence Act, very good. All right, so of course in a Queensland situation. Yes, Dani? What was that, sorry, Dani?
Oh no, sorry, no, it's not in Queensland, it's in the Commonwealth.
Right, yes, you've got to be
Section
careful.
98, but it's
You're looking at the Uniform Act, the Commonwealth Act. So yeah, you've got to be careful with that. So have a look at section 132A, 132B of the Evidence Act, and I'm reading from my brand new text. The common law is modified by those sections of the Evidence Act. They're inserted following the passage of the Criminal Law Amendment Act in 1997. So section 132A says that in a criminal proceeding, similar fact evidence, the probative value of which outweighs its potential prejudicial effect, must not be ruled inadmissible on the ground that it may result from collusion or suggestion, and the weight of that evidence is a question for the jury, if any. Now, what does that section mean? Well, what it does is overcome the situation where a court would seek to exclude evidence of similar fact evidence on the basis that it may have been concocted by a number of people colluding. So if there is one person, teenager, who comes forward to say, I was sexually assaulted by this person in this way, that's evidence. If you have 5 people that independently come forward and describe the nature of their being assaulted by the same person in the same circumstances, then that's evidence of similar facts. And at common law, the courts would generally exclude that type of evidence on the basis that it may have been presented as a result of collusion between those complainants. Section 132A overturns that, and now we have that statutory provision to say, just because the evidence may have been presented as a result of collusion or come into existence because of that, that doesn't mean it must be excluded automatically. Now, the other statutory provision is section 132B, which talks about evidence of domestic violence, and it says that relevant evidence of the history of domestic violence between the defendant and the person against whom the offence was committed is admissible in evidence of the proceedings. So what we're talking about there is more a general ability to introduce into evidence things that had happened within that relationship as evidence in the proceedings, and it may impinge on issues to do with propensity and similar fact. Now, Bryony, at the Commonwealth level, you are right, we're dealing with sections 94, which deals with application, 97, which is the tenancy rule, and 97, I think, is the coincidence rule as well. So have a look around those sections at the Commonwealth level. And all of this is a balancing act. It's a balancing act to ensure that there's fairness in the process and there's proper evidence which is presented to prove that someone is guilty. Now, Section 15 of the Evidence Act in Queensland is relevant, and it talks about questioning a person in criminal proceedings in circumstances where the person gives evidence. Now, we know, of course, that if someone is charged of a criminal offence, they don't have to give evidence, do they? In fact, if they're under investigation for a criminal offence, they don't have to give evidence. But what happens if a person chooses to give evidence? In those circumstances, the questioning has to be fair if the defendant chooses to go into the witness box. And Section 15 says that the person is not entitled to refuse to answer a question if the question relates to the offence about which they're charged. So if they're giving evidence in defence of a charge of grievous bodily harm, and the prosecutor in cross-examining says, did you commit this offence of criminal or grievous bodily harm? At that stage, having submitted to the court, they can't then say, I refuse to answer that question. They've got to answer it under Section 15. But they can't, the prosecutor can't ask questions or require an answer in relation to anything that shows or tends to show that the person committed or has committed or charged with any other offence. That is, any offence other than the one that they're there for at that time, or even that they're of bad character, unless the question is directed to show that the matter for which the proof is admissible demonstrates that the person is guilty, or is directed to show that the proof shows that any other person charged in the criminal proceedings is not guilty, or if they're dealing with circumstances where they have already led evidence of character against other witnesses, then they become fair game. So have a look at Section 15 of the Act. And Section 15.2 of the Act deals with, if you like, losing the shield. So if we talk about a defendant having a shield to be able to say, I claim privilege, I don't wish to answer those questions, Section 15.2 of the Evidence Act takes away some of those abilities, and there are some examples there. Okay, and if there are consequences to losing that shield, so have a look at those sections of the Evidence Act that we've talked about tonight at a state level, particularly 132A and 132B. Have a look at those sections of the Uniform Act in the 90s. Have a look at Section 15 of the State Act. And I'm sorry I'm bouncing between state and uniform. Also, have a look at the Criminal Law Rehabilitation of Offenders Act from 1986. Section 3 talks about a rehabilitation period, and that might be useful to have up your sleeve because it has the effect of causing some convictions to become what we call spent convictions that no longer apply in some circumstances. Now, to further confuse and bounce around between the state and federal, also in the federal sphere, in the Evidence Act federally, have a look at Section 110, which is talking about evidence of character of the accused person. And it says essentially that the hearsay rule, the opinion rule, the tendency rule, the credibility rule don't apply to evidence adduced by a defendant to prove that the defendant is, generally or in a particular way, a person of good character. So if a defendant tries to prove that they're of good character, be aware that that opens up a whole range of prosecutorial tools to attack them with. I mentioned I think the Criminal Law Sexual Offences Act previously, but have a look at the Criminal Law Sexual Offences Act 1978. Have a look at Section 4A, which deals with evidence of complaints generally. And that's probably all you need to consider today. I need to just make sure that all of these things are completely up to date. I think they are, but just something in the back of my mind has just jumped into my head saying we've got to check some of these laws, make sure that they're all unmodified from when I prepared the notes. I think they are, though. All right, sorry to leave that little bit of confusion at the end. So tonight, I hope what we've picked up on is this, that circumstantial evidence takes lots of different forms, and it is possible for a person to be convicted based on circumstantial evidence. But we need to tread carefully when we're dealing with circumstantial evidence. And if your defence counsel and the case against your client is just circumstantial evidence, then bear in mind the threshold test, that in order for it to support a conviction, there must be no other reasonable hypothesis on the facts that's consistent with innocence. So what you're looking to do is argue that there is a reasonable hypothesis on the facts, circumstantial facts that are presented, that is consistent with innocence. Then you don't have to go into evidence, etc., that you might give. We've identified tonight that propensity evidence, character evidence, similar fact evidence are all examples of circumstantial evidence that may be relevant in circumstances, but courts are very careful to guard against allowing that type of evidence because it has a very strong prejudicial effect and not necessarily a strong probative effect. And we've talked about the statutory exceptions and the statutory rules that overturn the common law, both in the federal sphere and in the state sphere. Federal sphere, I think we've only talked about the Evidence Act, Commonwealth. State, we've talked about the Evidence Act, but we've talked about a couple of other pieces of legislation as well. So have a look at those. Before I wrap up, there's just one other thing that I want to pose, and let's go back to Jimmy and the trial. The water trail between the back door and the kitchen. It's circumstantial evidence, but it's sort of circumstantial evidence that, in a way, is akin to DNA evidence. Let's think about this. Mum saw the water trail and linked that water to the fact that Jimmy was wet, and it placed Jimmy at the scene of the back door, didn't it? Because Mum inferred from the circumstantial evidence that she saw between the back door and the kitchen that Jimmy must have put it there, and he left that trail of water behind. It's the same with DNA. So if the case against an accused, in part or in full, is based on the fact that his or her DNA was found at the scene of the crime, it's a little bit like the water at the back door, isn't it? It's more specific in that it relates to an individual person, but it's still circumstantial evidence. It's not direct evidence. It's circumstantial evidence that that person was at that location, and we can say that because of his or her DNA being there. All right. Any questions for tonight? You've been very patient and hanging in there for me. Thank you. I know it's hard when it's only a small class, but you're doing well. Any questions, comments? All good? Okay. John, if you're acting as prosecutor, how do you introduce the similar or propensity evidence if you know that it has sufficient probative value? Look, realistically, it may be that you have a discussion with your opponent if you wish to lead this sort of evidence, and it may be that your opponent objects to the inclusion of that evidence. More than likely, it will be the subject of a pre-trial application and hearing in the absence of the jury to determine the admissibility of that type of evidence. So there will more than likely be a ruling on it. It would be a very brave prosecutor to just introduce it without prior notice to the opponent or to the court, because then there's a very real risk of a mistrial once we've got the jury there, if the court rules against it. So if the prosecutor feels that it's relevant and it's admissible, it'll be disclosed that that's the issue that's going to be undertaken. There are disclosure obligations that are imposed upon prosecutors, and defence will have an opportunity to argue against its admission, probably in a pre-trial situation. I hope that answers your question. Okay. All right. All good. We might wrap up for tonight. All the best, and we'll see you next time. Okay. Bye then.